and students under the PU education boards must follow the dress code prescribed by the college development committees or administrative committees. Shockingly, the government order that has been issued states that if a dress code is not fixed, then students must not wear clothes that threaten equality, unity, and public order. Women and students have thus been made to choose between their right to education and their right to choice in clothing and bodily autonomy. In several instances, even being made to remove their headscarves in public to enter schools or take their exams. These events have been shocking and are a concerted assault on the fundamental right to education of these students, their right to choice, freedom of speech and expression, and more importantly, their bodily autonomy. In light of these events, we found large spread confusion both within the legal fraternity and the general public at large regarding these issues and what place they find within the law and the Constitution. Therefore, in order to foster a discussion on these issues, place them within the Constitution, we invite you to this special webinar on women's autonomy and right to education in the eyes of the law. We're joined today by two speakers, Senior Advocate Harish Narasappa and Supreme Court Advocate Shah Rukh. Harish Narasappa is a senior advocate practicing in the High Court of Karnataka and regularly appears before the courts on questions of constitutional importance. He has read law at the National Law School of India University and at Oxford University. He's also the founder of Daksh and the co-founder of Samvad Partners. Welcome to our webinar, sir. Shah Rukh practices at the Supreme Court of India and read law at the National Law School of India and at LSE. She also has a degree in psychology. She's appeared before the courts in several important matters pertaining to constitutional rights and importance. I'll now hand over the discussion to Advocate Harish Narasappa. Sir, you can unmute yourself.
Okay, sorry, there's some trouble with my connection. Just give me a second. Don't seem to be able to turn on my video. Can you do that?
Yes, sir. Just give me a minute.
Okay. It doesn't matter. I think we're here to talk and not necessarily see each other. So let me start. Okay, it seems to have come back on miraculously. So thanks to Ilaj for inviting me to this discussion today, and I'm glad to see, given the nature of the topic and the seriousness, serious concerns that the developments have caused all of us. I'm glad to see that many of us have spared time on a Sunday evening to engage in an interesting discussion about this issue. And I'm glad that the way you have framed the topic for today's discussion, I think captures the essence of what we're discussing. And as usually happens in emotive issues, I think a lot of important issues and important concepts get lost. In a way, the sense of the mob or the ideas of the mob takes over as to what the issues are. And so when you frame this as an issue as an issue concerning women's autonomy and the right to education, I think it captures the fundamental problem that we are facing today, which is lost in the noise that has been created by around, the right to religion. I'm not saying there's no right to religion involved here. I think there's a serious question regarding the right to freely practice your religion and the freedom of conscience involved here. But I think far more important is the right to education and freedom of choice. And it saddens me on two. Firstly, let me share my disappointment with the debate that's going on even amongst lawyers and in society generally. I think it's being portrayed as a conflict between two separate religions and between two sets of people. A group of girls who are wearing hijab and a separate set of people who are wearing saffron shawls or other markers of their own religion. And that is a sad part, because what we are not really looking at is what does this prevention of people entering educational institutions, what does it really mean? It means two things. One, you're telling someone that while imparting education, somehow religion is linked to it. And if you come dressed in a particular manner which shows your religion, then this education is not for you. And I think that goes, in my view, against the fundamental assumption beyond the right to exercise your freedom of conscience and the right to profess and practice your religion. I think it hits at the right to equality, being expanded to livelihood and other things. But and of course, the second thing is the freedom of choice, particularly for women. And this freedom of choice, and we can discuss this a bit later. I don't want to take too much time initially, but the freedom of choice also is being somehow made, somehow getting confused. I think what is clearly at issue is the decision to wear a particular clothing, particular kind of clothing, should be left to the person who is wearing it. Now, it is being confused with the imposition of that clothing by religion, by a particular religion. That's a separate debate. If there is imposition, then that's a separate debate to be framed within the confines of that religion. But in the context of education, I think it's an irrelevant question as to whether a particular religion is asking you to wear a piece of clothing or not, and whether that is an essential part of that religion, is, in my view, not directly relevant to the fundamental question at hand, which is the right to education and the right to exercise your freedom of what kind of clothing you want. The second question, which I think is, again, an irrelevant consideration, but has become the topic of discussion, is whether you exercising your choice is somehow affecting somebody else's decision of what they wear. And I think it is irrelevant. And whether your exercise of choice is somehow adversely affecting the right to education or the right to religion of somebody else. And I think neither of them, in my view, neither of those questions can be answered as yes. I mean, the answer has to be no. So and the sad part is that, and while the case is still going on before the High Court, so I don't want to spend too much time discussing what's going on in court. But I do find that some of these questions have not been articulated properly until now. Maybe they will get articulated over the next few days, and I'm sure these proceedings are going to the questions may get raised in the remaining days. So, and being lawyers, I think we should stay away from discussing what is going on in court to some extent. So let us take this in the broader context. And it is not, so the first 2-3 propositions which I want to lay down here before Shah Rukh speaks is, A, this is not, in my view, the question of the essential practices of a particular religion. It is a much wider question. This is a question of the right to education, which has been recognized as part of Article 1. There's a question of freedom.
Sir, I think you've been muted. If you could please unmute yourself.
Okay, I think I had been, I think we got disconnected. I'm not sure where you lost me, but anyway, so I think in terms of framing the issues for discussion, one, we should look at the discussion than just the essential practices test as is being made out both in the media and in the legal debate. Two, I think it is about freedom of choice. It is about the right to education, and also whether there is discrimination in the context of the state telling people of a particular religion, denying the education to I need to look at Article. It is just the Article 20. I think it is about Article 19. So I'm glad that this question that Ayla just framed the question, encompassing the issues that are the larger issues that are involved in this unfortunate saga that's going on. So let me stop there and let Shah Rukh speak, and then we can take some questions later.
Thank you. I'll hand it over to Shah Rukh now. Shah Rukh?
Thank you very much. I think there's a problem with my connection as well. So let me not switch the camera on. Let me just start to speak, and then I'll switch it on as we go along when it stabilizes a bit. I also want to start by saying that I particularly like the framing of the subject of today's meeting. It's different and it's imaginative. And I think it takes the discussion away from the so-called hijab row to what, to my mind, is actually the issue here. And second of all, I do want to say that it's always a pleasure speaking at LRG, but especially today because I get to be on the same panel as Harish, who's my senior from law school, who I respect a lot, and who I haven't seen in years. But now, having said that, to start with how I understand the problem, to my mind, the legal case before the Karnataka High Court is a batch of writ petitions filed by women who are students and who also happen to wear the hijab. So these women are going about their business. They're being politically articulate. They have opinions on religion, on culture, etc. And they are going to college. And one fine day, when they arrive, they are unceremoniously turned back, and they are told that the College Development Committee has now passed an order saying you can't come in with your hijab on. So then some of them at least go back to the rules and they consult the rules and they find nothing in the rules that gives the CDC the power to come out with a bar like this. And this is playing out in public narratives when the state seeks to belatedly correct the situation. So the government order of 5th February inserts this power belatedly. It inserts a power that gives rights to the CDC to prescribe clothes that are apparently in the interests of unity, equality, and public safety, which is overbroad, which is vague, but such a power is given with, again, apparently retrospective effect. Now, the women have gone to court impugning two actions. They are impugning the action of the CDC, A, and they are impugning the government order. So what is the question before the Constitutional Court? According to me, the only question is, was the CDC's action good in law, or was it ultra vires all rules? And two, was the government order good in law? It's apparently derived from the Karnataka education rules. So the court needs to see whether they actually have that power and can they retrospectively correct a situation. But in the event, these questions are not being asked. What is being argued is the apparent right of the women to wear a hijab or not. And that, to my mind, is a complete inversion of the problem. I'll give another example. Supposing 1 month before exams, the CDC were to come out with a rule saying we are changing the grading system. So 1 month before exam, CDC says that now onwards, we'll give you 60 marks for class participation, and we'll give you 20 marks for attendance, and we'll give you 10 marks for field-based projects, and only 10 marks for written exams. What do you think would happen? To my mind, there'd be writ petitions galore. Everyone would go to court. But what would be the questions before the court then? I think the court would consider the jurisdictional incompetency of the CDC. The first argument would be that the CDC had no right to tinker with the grading system. And at least the second argument would be procedural arbitrariness. Everyone would say that, there was no discussion, there was no due notice. How can you change the grading system 1 month before the exam? And then we'd also talk about manifest arbitrariness. Why are you doing this? What is the legitimate purpose? What is your cogent reason behind doing this? I don't think we jump straight to what rights the students have. We would first talk about why the committee is doing what it is doing, why the GO is doing what it is doing. Does it have the power? Does it have the competency? Or is it just manifestly arbitrary what they are doing? Right? And then it would be for the CDC and it would be for the government to defend themselves. They would probably come out with answers and they would say things like, no, we are doing this to safeguard academic standards. And then the discussion would probably go off in another direction, and we would probably discuss what constitutes academic standards. Does academic standard get constituted by involving stakeholders, taking them into confidence, asking them, and together deciding how they should be evaluated? Or does it get constituted by messing around with schedules, right? And probably there would be a whole lot of other questions about public funded education, about stakeholders, their rights, the right of the funders, the right of the state, etc. Right? But to my mind, we would not immediately jump to the question of rights and start to evaluate rights and talk about whether they have a right, whether they don't have a right. I hope we would be scrutinizing these orders and these actions in their own right. But in this case, I don't see that happening. I don't see us talking about manifest arbitrariness as laid down by the Supreme Court in Shaira Bano, for instance, where the court has said that just because a statutory body can do something doesn't mean that it has unfettered powers to do it. You have to show, you have to give good reasons for doing what you are doing. You have to respect legitimate expectations. You have a duty towards your stakeholders of audi alteram partem. You have to hear them, right? You have to show that there's no impropriety, there's no irrationality, you are not acting in bad faith, and there is no improper purpose. None of these questions have been asked. We're only talking about what rights, if any, the woman has to wear a hijab. And that is completely irrelevant to my mind. Because to my mind, any restrictive order about grading, for instance, has to first be scrutinized on its own standing, whether it violates a fundamental freedom or not. You have to first show me why you're doing what you are doing. Now, instead of all of this, I think the problem has been inverted. So what is happening here? What does an inversion do? I think what the inversion does is, instead of scrutinizing each restrictive order in the spirit of constitutionalism, we try to look for reasons for exempting actions from such restrictive orders. So we don't say, why are you doing this? Instead, we start to ask, well, even though you are doing this, don't do this to me because such and such freedom of mine is getting inverted, getting breached. And I also think that some of the questions that are falling from the court, for instance, the court said, if we can disallow ticketless traveling, why can't we disallow the hijab? Then the court asked, if we can disallow firearms in the classroom, why can't we disallow the hijab? Now, again, to my mind, the court is starting from a position where restriction is the default position. You can disallow, you can disallow, you can disallow. But to be allowed in, you have to show the court why you should be allowed in. Instead, the court should be asking, why have you restricted ticketless traveling? And the state should be able to give cogent reasons for doing so. Then the court should independently ask, why are you disallowing firearms in the classroom? And the state should be able to give cogent reasons for that. And then the court, when it scrutinizes why the state is trying to bar hijab, would itself see the difference in these verticals, in these very different contexts. The court would not try to club all of them together and say, well, if we can bar this, why can't we bar that? That is an inversion of the problem. Third thing, the court, even though it hasn't said so, but the implication is that discipline in itself is a cogent ground. The court has said, well, if uniforms discipline, then why not? That is a cogent reason. The court has also said that discipline in some way contributes to academic standards. And again, I find this disappointing more than anything else, because on the one hand, hijab is being discouraged or hijab is being criticized because the impression is that hijab polices women's bodies. But then the court thinks that it is okay, that it is sought to be replaced by a uniform prescribed by the secular state in order to inculcate discipline. So policing of women's bodies when it is under the garb of the hijab is sought to be replaced by a uniform in order to inculcate discipline. That is ironical. When we were at law school, we were taught humanities, and I wonder why not enough of humanities is used now in the framing of issues in the law courts. So while the court is talking and thinking about discipline and the value of discipline to children, there's not enough discussion, for instance, on political theories that talk about biopolitics, how politics is played out on human bodies, and how that is one way, one tool of managing populations. If we had all of those perspectives, then perhaps we'd think differently about discipline in schools or uniform in schools. I agree that uniform is an equalizer of sorts, but at the same time, in our education system, especially in our public funded education system, uh, where there's no equality of opportunity, no equality of resources, uniforms become more symbolic than anything else. We talk about uniforms while not talking about the more structural issues in our education system. I want to now talk about social conditioning. Hijab, again, is being scrutinized as a manifestation of social conditioning. Women don't really have choice. Women have acquired it because of certain kinds of cultural, religious, social conditioning. It may or may not be true, but our entire lives are products of social conditioning. Fashion is about social conditioning. Consumerism is about social conditioning. Everything is about social conditioning. We need to ask ourselves why certain forms of social conditioning are given more leeway than others. Why is one form of social conditioning okay and another form not okay? And while we are on the subject of social conditioning, let's also talk about judicial conditioning. I was amused, and I've been thinking about this. Psychologists do this. They play with word associations, and it's supposed to sort of indicate your subconscious mind and how it associates certain ideas with certain things. Again, let's look at what has fallen from the court. The court has compared hijab to firearms, which is extremist, which is violent. The court has also compared the hijab to ugliness. When a girl is ugly and she wants to cover her face, then she would wear the hijab. Again, when talking about social conditioning, judicial conditioning, these questions are revealing in what they tell you about word associations or associations between ideas and certain things. Again, judicial conditioning. I think it's definitely a product of time and space, how cases are judicially reasoned, even. So let's just, as an example, talk about Article 25. Article 25 promises freedom of conscience and also the right to freely practice, profess, and propagate one's religion, subject, of course, to public order, morality, and health. Explanation 1 then clarifies that the wearing and carrying of kirpans shall be deemed to be included in the profession of the Sikh religion. Now, I've been asking myself, I've been wondering why the explanation mentions the kirpan and not the more obvious turban, for instance. And one interpretation could be that the Indian secular public space at that time was easily able to accommodate innocuous garments that were different in that they were recognized markers of particular identities. And the kirpan is specifically mentioned only because it's not just a sartorial accessory, but it's also a sharp-edged weapon. And even then, the constitution is trying to accommodate it. So at the time, I'm submitting that kirpans were not considered a threat to others in the public space. Whereas in this time, on the other hand, mere garments are arousing hostility. And allegedly, they are able to rupture unity and rupture public safety. So therefore, the court's question equating hijab with firearms also exhausts that extended space for identity markers that explanation 1 of Article 25 had sought to create. Third of all, I've been asking myself how it is if judicial reasoning is not subjective. How is it that the South African judgment that has been cited in the law court, and I'll cite from it very briefly in a moment, how is it that it's so different? South Africa and India have similar legal traditions, South Africa was inspired by the Indian constitution. South Africa relies on Indian constitutional precedents. And yet the South African judgment is able to say that the court should protect the voluntary as well as the obligatory practices, because that conforms to the constitution's commitment to affirming diversity. It also says that the symbolic effect of denying the right to wear a nose ring for even a short period would send a message to Sonali. Sonali is the petitioner there, will send a message to Sonali that her religion and her culture are not welcome. And therefore, she should be given a right to wear her nose ring in school, even if it does not conform to the school's uniform standards. I'm asking myself about judicial subjectivity. I'm asking why the South African Constitutional Court is able to give a judgment like this, and our Constitutional Court, at least in its interim order, and at least in its line of questioning in court, is not able to do the same in this moment, in this context. And finally, coming to the question of the ERP, the essential religious practices, Harish has already sort of mentioned that it's not a very accurate test because it misses that there may be more than one motivations for any cultural or religious symbolism. There may be 1,000 reasons. So it is not able to capture the entire context of any action. But that's one part of it. My discomfort with essential religious practice emanates from the fact that it tries to constitute an entire community in a particularly undemocratic way. It always turns to scriptures, it turns to the Quran, it turns to the Hadith, but it completely negates the lived experiences of Muslim people, of Muslim men and women. It completely negates the fact that even Muslims negotiate their faith every day in their lived realities. Muslims don't always turn to Maulvis, Muslims don't always turn to the Quran, Muslims don't always refer to the Hadith in everything that they do. A lot of it is just plain negotiation, a lot of it is individual interpretation. A lot of women I know, and I've done this myself, a lot of times when you do something, you stop for a second and you ask yourself, would Allah really mind? Maybe not. I'll just do this. I don't think Allah would mind because I'm doing this with a pure heart. So these kind of negotiations are happening all the time. But the construction of the Muslim community is in the image of a universal, unbending Sharia, and the Maulvi who's sort of the patriarch, as opposed to Hinduism, which is constituted as a much more eclectic faith. So you never imagine Hinduism and Hindu practices in the same unbending way. In the present case, for instance, if certain people are coming to class with saffron shawls and saffron flags, then for those people, that's assumed to be their essential religious practice because, hey, it's an eclectic faith. But what happens is that in the process, the basis of reorganization of the Hindu faith, which I submit is caste, is never scrutinized in the same way. Therefore, in this case, you're thinking hijab and you're thinking saffron shawls, but you're not thinking segregation in public schools of Dalit children. You are not thinking how Dalit cooks are not employed as public policy to cook midday meals. You are not talking about fraternal dining in public schools. You're talking about symbolisms of saffron flags. So again, the most structural basis of reorganization of Hinduism, which is reflected every day in our public spaces, is never scrutinized. And with that, I come to the very last part, which is sort of a comparison or a comment with French secularism. And I want to say that, quoting Talal Asad here, who's critiqued French secularism, and he says that really it's not so much secularism as a kind of assumption that the religion of the ruler should be the religion of the masses to avoid any kind of friction in society. So you choose the dominant religion and you expect everyone to more or less play by those rules. So the French had never had a problem because everyone was more or less Christian, but now they do with the immigrants. So now they see whatever is foreign and not part of their traditional religion as communitarian, as not secular. So therefore the veil that the immigrant women wear is considered an assault on French secular republic. But symbols of Christianity that are imbued in French daily life are not considered a problem. They're very much considered part of the French Republic. But what the French do is they treat foreign as extreme. Something that is foreign is extreme. Something that is foreign is not a part of the French secular culture. In India, on the other hand, Muslim visual representation has always been around in one form or another. So Muslim visual representation cannot be considered foreign. So what we are seeing is an inverse. Muslim visual representation is being painted as something that's extreme in order to then make it sound foreign. The French pick up foreign things and make it sound extreme. Here in India, we are treating as extreme cultural symbols that we've always seen around us. And we are making them now sound foreign to our public secular culture. Thank you. I'll stop there for now.
Thank you, Shah Rukh. I would request Advocate Harish to respond and give his comments if he has any.
Yeah, no, see, I don't have much disagreement with what Shah Rukh has said. I agree with almost everything she has said. I think there was one particular petitioner has brought up the issue of government power, and I think that issue was argued. I haven't watched the entire arguments, but I think what was reported is the basis of the GO as well as the powers of the CDC have been questioned. And I agree with her that, and that's one of the points that I made earlier. I think I was having a lot of connection issues, so I'm not sure what was heard and what wasn't. But I agree with Shah Rukh that, to frame this issue as merely one of wearing a piece of clothing which has caused some sort of public order problem for the state is nonsensical, right? I think that is not the issue. The issue, of course, is political. I think again, that is something we should not deny. I think if we deny that there is a political angle to this, then I think we cannot discuss the issue out in very freely and in its true ramifications. So there is a political angle, but what bothers me is the political angle seems to be that, okay, we can determine what women of a certain community should wear or not wear. And I think that, according to me, is a much wide, goes beyond, the essential religious practices test. So as a lawyer, I find, framing this issue in the context of the essential religious practices test to somehow justify the wearing of a particular piece of clothing to college or school, I think is limiting. And that was the point I wanted to make earlier. And I wish that we had framed this issue in a much larger sense. But again, as when a matter goes to court, you don't necessarily want to frame it in all its ramifications. You want to get a particular relief, and the relief here is that you should be allowed to go to college or school wearing a particular kind of clothing that you are comfortable with. So to that extent, if the relief is framed narrowly and the petitioners are petitioners' objective is to get that relief, then I think they're entitled to frame it narrowly. But the court, and again, it's only an interim order, and we need to wait and see what happens. But the way the court drafted the interim order was very narrow, and the court should not have done it, because again, whether the court heard all the issues from all the lawyers by then, there are jurisdictional problems. A single judge heard it for 2 days, then it went to a full bench. Now we are before a full bench. There are problems of natural justice involved there. I think essentially the petitioners have lost an appeal. If it was heard by the single judge, then there would have been an appeal to the division bench, and then to the Supreme Court. Then now essentially the only avenue left is to go to the Supreme Court if whoever loses in this case. Although in this case only the petitioners can lose, because I don't see what is the state's business to have made this GO in the first place. So clearly there are many other issues around how the matter has been dealt with as purely as a question of technical law, in terms of GO, in terms of the CDC, in terms of how the CDC is constituted as well. And again, I think in earlier discussion I pointed out that having elected representatives sit on CDCs is goes against, in my view, the fundamental concept of separation of powers. But I noticed that one of the petitioners has also brought this up in the arguments. So I think there are many issues. So as lawyers, we need to understand that while all these issues may not get addressed in these petitions, there are issues that go beyond what the media is portraying, which is wearing of the hijab and coming to school. Now, even if you reduce it to that limited point, my point again is, and we should not narrow it down in that context. And so I'm very clear that it's not a narrow debate. But even if you reduce it to that narrow debate, what is the problem? How is imparting education affected by a choice of clothing? It is not. And educating everyone, particularly women, and because in the context of where we were at 1947, 1950, when the Constitution came in, and education being a central piece of what the Constitution envisaged in terms of the change it wanted to bring in the country, to use a marker which is irrelevant to the imparting of education is completely. Shah Rukh used the words arbitrary, manifest arbitrariness, all those things. I think I'm sure we can come up with many other words to describe that. It cannot stand. There's no logic to this, right? So if you are to look at purely as a logical exercise of lawmaking, and this is not lawmaking. The college development committees can't make laws taking away fundamental rights, right? Or even GOs, for example, can't make laws taking away fundamental rights. The law is very clear again on that. If you're dealing with a Part 3 legislation, Part 3 right, then to restrict it or to take away, it has to be, you have to pass a law, and then that law has to be debated and examined at the threshold of Part 3. But to use these vague GOs and vague CDC orders, I think is not correct in law. So I'm very clear about that. But what particularly bothers me is the narrowing down, and I'm repeating this point, but I want to make that because that is what has been agitating me, at least, is the narrowing down of this issue to clothing and religion. I think the issues are much larger, and the one point I think which I like which Shah Rukh said is how individuals engage with religion in this country, right? Because religion is everywhere in this country, right? We're not like a liberal democratic state in some other parts of the world where religion may not be staring at your face in every activity. In our country, it does. So it is not just how each one deals with his or her own religion. It's also how our rights that are guaranteed to us by the Constitution, which none of us, no Indians had exercised and enjoyed before 1950. The Constitution gives us rights which we in this country never had. So how do we deal with those rights that we are guaranteed by the Constitution, to what religion mandates, and how do we negotiate those rights as well is at issue here. And I do hope that we're able to deal with some of these issues. But what would be very good is for these girls to get some relief, and that's the first. I think that should be the first objective. But I feel that we have entered a realm of attack on rights that we had not seen before in this country. And I'm sure that we will face more of these kinds of attacks, and we need to find ways to respond to them legally, in how we frame the questions, how we frame. So we should also think of framing the issues correctly when we go to constitutional courts. And I think that's a critical message for all of us as lawyers.
Thank you. Shah Rukh, if you have any comments, you could give them as well, and we can move on to a discussion and questions from the participants.
Thank you. Very briefly, I stand corrected. Harish is very right in pointing out that at least two counsel for petitioners, Mr. Mochala and Professor Ravi Verma Kumar, did indeed make submissions that the actions of the educational institutions were manifestly arbitrary. I think it was done on the fourth day. So the argument I was making was that somehow that didn't come across as the primary argument, but this argument was certainly made. And Mr. Hegre also talked about the lack of democratic participation. He kept saying that this should be resolved democratically. So he was talking about procedural arbitrariness. I stand corrected. Thank you.
Thank you. We've received a few questions, and I would request the rest of the participants as well to post their questions in the chat box. And if they would like to say anything, to post it in the chat box as well, we will put it forth in the webinar. For now, the first question that we've received is about the framing of the issue under Articles 14, 15, and 19. And what manner of framing should have been done under these articles? If either one of you could respond to it. Would you like for me to list 2-3 questions and then we can address them?
Yeah, maybe we can take 2-3 questions together.
All right. So the first question is regarding the particular framing of the issue under Articles 14, 15, and 19, and how it should have been framed. The second question is, given the comments that had been made over the course of the hearing regarding uniformity, and given the fact that uniformity seems to be the argument prevalent across the legal profession and the general public, whether this is a question of uniformity, whether it finds a place in law. One of the examples was pointed out by Shah Rukh as well, about a girl student having a medical condition that would make her ugly and forcing her to cover her head. And if she has to then be made an exception of and be permitted to cover her head, whether Muslim students should also be subject to the same exception under the garb of uniformity. So the second question is about uniformity. The third question is that certain fundamental rights seem to be at variance with one another. And if there is such a variance, which one, given the framing of the issue by the High Court already, should take precedence over the other? Since they're very broad questions, I'll leave it at these 3 questions.
Shah Rukh, do you want to go first?
No, Harish, you go first.
Okay. Okay. So the High Court has not framed any issue, right? I mean, so that let's be very clear. I think the arguments are going on. I mean, this is not like a trial where issues are framed, but I think maybe the reference was to the way the interim order was drafted. And to be fair to the High Court, they were being asked to give some sort of an interim order. And actually, on that day, I was watching the proceedings, and I think Mr. Hegde and the petitioner's lawyers and the court also asked whether the Advocate General or the state could give some, could ensure that things continued without any, interruption, and students should be allowed to go to school. But the state did not make any commitment. They, in fact, said that there were law and order problems. So the court may have been responding to that, but nevertheless, I think the interim order has created a lot more problems than what existed before, and has led to incidents that should not have happened. Right, and the court has not corrected that. The court has not considered those incidents and the effect the interim order has had, although many lawyers did bring it to the notice of the court that some more, there were incidents which were creating, like people were forcing women to remove certain pieces of clothing on the streets, and being forced to go home and all that, and the court has not responded to that. Maybe they will respond in the next few days. I have no idea. But that's one aspect of it. But how do you frame the issue in terms of Article 14 and other rights in the Constitution? I think, see, right to education is now guaranteed. I mean, I know up to 14 as per 21A, but if you read the jurisprudence on Article 21, then I think there's a case to say, all the way, until you reach the, what we call the examination level to go on to higher education. So if you're preventing a certain category of students to come to schools, and then, is clothing a marker to prevent them from coming to school? I think that's one way to frame the issue on Article 14. In 19, you could freedom of choice, freedom of expression is something that you can frame under, I believe, here, because if you're wearing a particular kind of clothing, you're expressing your choice, right? Freedom of speech is something we can also bring in. It's a long shot, but it's something we can bring in. But the Article 21, where right to education and right to livelihood is recognized, is certainly something that I would say is being violated here. And it's not a stretch, although Article 21 is used more as a residual right, but there's enough jurisprudence now, I feel, that we can bring in the fact that if you're denying somebody education, then you are essentially denying livelihood as well, and right to life as well to certain kind of people. So I think that is, those are all methods of framing questions, that we can consider. Again, I want to point out again, this is not to say that these questions should have been framed. As I said, petitioners are looking for a particular kind of result and they go with it. These are all the larger questions in the incident that we are discussing, and we should not forget that.
I'll just add one or two things to what Harish has said. To my mind, the uniformity is not a cogent ground. That's not what is being argued. As I understood it, uniform is a cogent ground, meaning that uniform, because it's an equalizer, because it develops collegiality between students, etc. That is the argument, not uniformity, but uniform in educational spaces. And also because it inculcates discipline. That has been argued. And that's the point I was making, that when you're actually criticizing hijab as a manifestation of social conditioning, then how can you treat discipline or inculcation of discipline as a public good? So you don't have a problem with discipline as such. You don't have a problem with social conditioning. You don't have a problem with social control. In fact, you're treating that as a public good, something that should be encouraged in educational institutions. So what you're basically saying is that the community should not do it, the state should do it. And that again is not a very logical argument. You're talking about who should be controlling whom. You don't have a problem with control itself. Also, security always comes up. So I think that that argument has not been made in court, but it's been made a lot in public discourses. When you cover the face with a niqab, then that's a security issue, apparently. But again, during pandemic times, they're barring the niqab, but they're not barring the face mask. You could be covering your entire face with a mask for COVID purposes. That is not a problem. But the niqab is a problem, which is again discriminatory, unreasonable, and manifestly arbitrary. And a third point, which is related to 191A, if you frame it as a right of expression, then law and order, interestingly, is not a valid exemption. That's not a valid ground to suspend someone's freedom of the right to freedom of speech and expression, because it may disturb law and order. It has to be something bigger than that. It has to be public disorder, which has been defined as by courts as being of a scale that is much larger than just law and order. But here the whole argument was that this action of hijab-clad girls will disturb law and order. And the courts went with it. The courts were very anxious to prevent any law and order issues. It's not the mandate of a constitutional court to get into issues of law and order. That's the executive should take care of it. The police should take care of it. Public disorder was not even mentioned. And yet they suspended the right to wear a hijab in the name of law and order.
Thank you. I think there was one more question that had been posed, which was whether fundamental rights appear to be at variance with one another here, and if so, which one should give way to the other. I think this is in reference to Article 25 and the other rights.
See, I actually don't think that there is a clash. Okay, I mean, I have asked myself this question over the last few days and last few weeks. Again, if we look at two scenarios, for example, if any of these girls were being forced to wear this clothing, okay, then there's a separate question and a separate right involved. And I don't think that, at least that has not come to attention, although there in the public discourse, there has been some statements by some ministers that, that girls are being encouraged to wear the hijab and thereby create this problem. But that again is not a problem for the state. That is between the individual concerned and whoever is forcing her to wear the state, wear a piece of clothing, or if she's prevented from being, if she's being prevented from wearing what she wants to wear. So if you take the second part of that, and for the moment, let us assume that all these girls who wore the hijab are doing it out of their own free choice and free will, then that's clearly now an action between the girls and the colleges and the state. Therefore, the issue gets narrowed down in that form, that of a secular activity of education being made inaccessible on the grounds of clothing. And there, I think it's very clear what the answer should be. if you read, part 3, I'm not saying there is no tension between different rights in some contexts, and we have seen this, over the last 50-60 years, how the courts have sometimes tried to balance between rights, and that's mostly in the context, again, if I may say so, in the context of minority educational institutions, reservation, and other rights. Now, here, if you take just this particular example, what are the rights that are at variance here? I'm unable to come up with anything. I refuse to believe that there's a public order situation, public law and order situation created by a set of people wearing a particular piece of clothing. And that's why I made the point. What is this for? This is for imparting education. Now, let us even take this to its logical conclusion. I think the law and order situation was apparently created because certain other students started wearing shawls of a particular color. Are you saying that our state is so weak that if two different people wear two different kinds of clothing and come to school on top of their uniform, the state cannot deal with it? And in this context, we should remember that we are not a soft state. I mean, we're actually a terribly hard state, which is willing to take away rights of people at the drop of a hat, right? So I refuse to believe that the state could not have dealt with this in a more easy method of resolution. It could have done it if the people in authority were willing to do it, whether it's at the bureaucracy level or college development committee level or the state government level. I think it could have been dealt with, but it has not been dealt with. It has been made a law and order problem, and the state says so. Now the law and order problem is being given as an excuse by the state, not by anybody else. So I don't think there is a question of conflict of fundamental rights here. I don't think so.
No, I completely agree. I completely agree with what Harish is saying. The only possible conflict could be between community rights and the right of an individual woman to not wear the hijab.
Yeah. Yeah.
But do we have any data? Do we have any ethnographic studies? Do we have any sample interviews, anything to suggest that a majority of these women are being forced to wear the hijab? It may be the case that some of them are, but on what basis do we presume? And again, that reinforces the image of the Muslim community as unbending, patriarchal, and tied to a notion without any space for negotiations. So we need something more than just a presumption before we assume that there is a conflict between individual and group rights. And again, to add to what Harish said about public law and order, public safety issues, the heckler's veto comes to mind. Repeatedly, we are seeing now in India that hecklers stand up and say that what you are saying or what you are doing is making me very upset. And if you continue to do it, I will get upset and I may disturb the peace. But the responsibility is put on the person's shoulder who's actually being told to shut up, not on the person who's asking him to or her to shut up. And that is the heckler's veto, where you shift responsibility from the person who's actually being marginalized to the person who's saying, get out of this public space, I don't like your face.
And going back to what I said at the beginning of this discussion, that's why I like how you have framed the topic. It is about women's choice. And that is important because too often in this country, we blame everything on the way women dress, right? I find it, it is absurd, of course, but I find it shocking that the issue comes up in different methods and manner. And in this context, I never thought that it would come up in the context of primary education and high school education. So that's a bit of a shocker. But so in another way, I mean, what you're essentially doing here is you're saying that I will determine the methodology or the manner of dressing for certain kind or certain groups. I think that through the heckler's veto, and that's the problem. I think that's a much more serious problem than saying, okay, then negotiating between community rights and individual rights. If you're negotiating between individual rights and community rights, then the forum is different, and what you're doing and how you tackle that is different.
Thank you. I will start 2-3 more questions. The first question is that the state has invoked the Sabrimala judgment and the Triple Talaq judgment to state that this is a question of constitutional morality and individual dignity, and that the hijab must pass this test of constitutional morality in order to be exercised. Is this valid in law? The second question is, wouldn't minority education institutions have the right and freedom to ban such religious gear in their institutions, pursuant to their fundamental rights? The third question is that the AG has submitted over the course of the hearing that the government order neither prescribes nor proscribes the wearing of headscarves. Is this valid?
Actually, I saw to take the last point first, and then I'll let Shah Rukh go for a while. I think I saw the AG's argument, and I think if he had stopped there, I think the court may very well have closed the case yesterday. But then he's going on to make other arguments. So the state, I think, is playing. I don't know. I hope if they clarify that stand tomorrow and say that there's no prohibition, then all they have to do is take that to its logical conclusion and tell colleges, why are you prohibiting it? If we have not prohibiting it, who are you to prohibit it? And I think they would end the matter. If that is indeed the case, and if the AG is right in his submissions, then I think he should take that to the logical conclusion tomorrow and make that submission. But as I said, it may not be the case, and that's why it's been going on for a few for a few months now. I think if that was the state's position, I think they could have dealt with this as I said, in a more peaceable fashion much earlier. On the constitutional morality, see, I think the context in which you're talking, in which the Sabrimala case was decided, and the concept of constitutional morality came in, is again in the context of somebody saying, I want to exercise my right, and the existing practices violate constitutional morality. Here, it is somebody else who is saying you should not exercise that right. I'm wearing a particular piece of clothing, and somebody else is saying don't wear that particular piece of clothing. Why? Nobody knows until now, right? And the only excuse that is being given is that it is going to create law and order problems. And therefore, I don't see the concept of constitutional morality as the court sort of developed in the Sabrimala case. I don't think that is going to tell you that you can't wear a particular kind of clothing if you choose to do so. I think that is the point that we are making. In fact, I would say constitutional morality will allow you to wear whatever kind of clothing you want to, as long as you're not causing problems. Real law and order problems, and not imagined law and order problems.
Shah Rukh?
Yeah, no, exactly. Again, I think constitutional morality in this case would apply to scrutiny of states' restrictive orders. Why are you passing orders? Where is the constitutionalism there? It would apply to a questioning of the kind of arguments that are being made, that discipline, in order to inculcate discipline, it is a good thing. That reasoning, according to me, uh, is against the notion of constitutional morality. Accepting orders as they come without scrutinizing them, as long as they don't breach any obvious fundamental freedom, is against constitutional morality. So I would apply that argument to the GO itself and to the impugned act, not to the wearing of the hijab. Question 2 was about what happens if Articles 25 and 26 come into conflict. So if you wear a hijab to, I suppose you meant a missionary institution, then what would happen? But again, I think it's a forced conflict. Why should there be a conflict? I mean, why can you not wear a hijab to a Catholic school, and why can you not wear a cross to a madrasa, etc.? I mean, again, the presumption is that in a minority institution, no other cultural symbol should be welcome. But these are things to think about. I don't see a conflict here. I see a forced conflict here. And third, again, what Harish said, that if the AG had stopped at that, there would be no case left. But I just add to that that he would have to necessarily withdraw the GO then, because what he's effectively saying is that it is overbroad, it is vague, it can be interpreted in any which way, which then makes that order vulnerable, and that order then should be either quashed or withdrawn.
Thank you. We have a couple of more questions and then we can wind up. One question is, would the POCSO and Juvenile Justice Act be applicable to the petitioners here? The second is any international law obligation under the Convention of the Rights of Child applicable here? Why hasn't the court raised this question? The third it would be a larger question, is what is the history of the essential religious practices doctrine, and is it what is actually contemplated under Article 25? There are three more questions, they're shorter questions, so I'll just list them out. What is the implication of the Supreme Court and High Court judgments invoked in the government order? And what should the role of lawyers be in such situations, especially when there's been a violation of the interim order and they cannot approach court?
See, violation of interim orders, and I'm actually going to make a larger point here, which should be an awakening call for all of us as lawyers. If we do a study of the number of court orders that are actually followed as against the number of court orders that are not followed by the government, I think you will all be shocked, right? Court orders are actually, and then you see the number of contempt petitions being filed in court against the government. I think the answer is very clear, right? So there's a larger rule of law issue here, that what court orders, how are they followed, and even how courts react to their orders not being followed properly. Courts don't, unfortunately, except in a few cases, don't take it to their logical end. They treat the state very gently in most cases. Leave alone sort of high profile and so-called sensational cases. Even in regular cases where citizens' rights are involved, the courts are very gentle on the state, and they treat the state as somebody who needs to be cajoled and hold their hands to follow the law, rather than imposing the strong will of the law. So there is a problem there generally, and so that's a larger rule of law issue. And I think if we start talking about that, I think we'll be here for a long time. So I think let's stop there. But what it's a genuine question. What happens? What should lawyers do when the interim order is not being followed? They have to go back to court, and unfortunately, because of the larger problems we have with how with the judicial delays and judicial the way cases are listed and all of that, we are stuck. This happens, and any lawyer will tell you, I mean, this is a daily affair, right? You feel something is urgent, it doesn't get listed, so you have to cope with it and find the earliest possible opportunity to agitate the issue, right? So that's what we need to do. I'm trying to remember what the other questions were. Shahrukh, if you remember the other questions, please go while I try to recollect. I forgot in my excitement about the rule of law
Harish,
point. I forgot.
These are all questions for senior counsels to address. One was about the ERP, the history.
Okay. Yeah. The history of the ERP, I think, it came very early after independence, right? I think it starts right from the Shirur case, and I think there was one more case, the Sayadna case before that, or I think they were around the same time. I forget exactly which came first, but I think so. It started maybe when the ERP was, and there was a dissenting judgment. There's a dissenting judgment by Chief Justice Sinha at that time, who said the ERP is not the right way to go. And in fact, he talked about the living experience of religion, how individuals experience religion, and and that should be a factor that we need to consider. And I personally feel that the ERP is not the right test to apply. So the history of the ERP, just to go back, began very soon after 1950, when the first of these cases came before the Supreme Court, the Shirur case, and that's why we know, even when this case was being discussed, how people were talking about how Shirur is also an Udupi, so how these cases have also arisen from the same city. So the question was how much should a secular state intervene in religious activities, right? And to some extent, Article 25 does talk about the ability of the state to regulate secular affairs of religious bodies, right? So maybe the court took that into consideration when they first conceived this test. But I think there's a need to relook at the ERP. And I personally feel that the approach should be from the Part 3 perspective. I don't think courts can, it's also extremely incorrect in my view that a writ court can sit and decide what an essential religious practice is. These are secular judges, right? They're not well versed in each of these religions. Some of them may very well be, but as a rule, right? Some of them may very well know the scriptures well and have read them well. But majority of the judges are not religious scholars. So how do you then determine what is essential or not? Is something we need to reconsider, and there should be some other test. I think some scholars have suggested some other tests. In fact, Chief Justice Sinha's dissenting opinion, I think, is a good place to start, and find another test. And maybe the constitutional morality argument could be useful. But all these are potential methods, but it needs to be reconsidered now by a larger bench of the Supreme Court, because that's where the ERP originated from.
I actually have nothing to add except good citation. Gautam Bhatia, he writes on everything. He's written a very, very precise article outlining the history of ERP on his blog. So I can cite that. But one point that I want to make about ERPs is that it's usually been used to prescribe or to scrutinize cultural or religious practices that are in immediate conflict with another fundamental right. It's not usually applied to a religious or cultural practice without any rhyme or reason. You're going about your business wearing the hijab, not coming in another person's way. So it's not, you're not questioned, you're not asked to stop and prove that it is an ERP before you can continue to wear it. It usually only happens when two practices, two fundamental rights come into conflict. The court has to see whether one should be barred, and then they see whether it is an essential religious practice or not, whether it can be barred without violating Article 25 rights. So that is one distinguishing factor in the present case.
No, I agree. And to just take that to the logical argument, suppose just for the sake of argument, you hold that, or somebody says that wearing the hijab is not part of the essential religious element of Islam, and a girl still wants to wear it.
Exactly.
I think there's a freedom of choice there.
Exactly.
Right? I mean, so I think that is why I said when I started that I don't think this is about the ERP and a particular religion. Tomorrow it could be to some other religion. I mean, if you want to wait, I think there are many.
My dupatta. I mean, it's like asking me to prove that wearing a dupatta is ERP before I can continue to wear it. And the response is, how is it even relevant?
No, there are. I remember, and having been raised in a South Indian family, when I encounter some North Indian Hindu families, and I see women wearing their ghungat, vague, where you don't even know, you haven't seen the face of the person for even after visiting their houses for many number of years. What is that? I mean, is that an essential religious practice test or not, or is it a choice? I think these are all, I think I'm very uncomfortable with this question in the context of education and in the context of dress being reduced to an essential religious practice question. I think that is the point that I wanted to make when I started this discussion.
There was also a question about case law that's been used in the GO and what is the relevance. And again, I want to cite, I think I see Afif here, he's written in The Wire, distinguishing each of these cases on facts and saying that they're actually not relevant to this particular fact situation where women have been wearing the hijab, they've been coming to campus, and suddenly you bar them. Those case laws were very specific on facts. One had to do with writing an exam and not allowing yourself to be examined before going into the examination room, citing parda. So that was a very specific fact situation that didn't apply to wearing the hijab in the normal course. And on that note, I also just want to bring in what Arvind has said in the chat box. He's referred to non-retrogression of rights, which have been articulated in the case of Navtej Johar. And it means that if you've enjoyed rights for a period of time, then you can't arbitrarily be deprived of the same, which is what is happening in this case. And then third was a question about POCSO and the Juvenile Justice Act being applied to these women. And I didn't understand that question, because do you mean as accused? Do you mean as victims? I didn't understand that question at all. And the fourth was about whether international human rights apply to this fact situation or not. And Harish, what do you think? I think they do, because we are signatories to all these international human rights conventions, and international human rights now do recognize clothing as a manifestation of the self, as an expression of the self. And in that sense, it is very much part of recognized international human rights.
Yeah, and if India is a signatory to the convention, then we are bound by those rights. And actually, one lawyer did cite a few conventions. I forget the name. One of the petitioner's lawyers did cite a few conventions.
Shahdan Farasat.
Yeah, he did. He did cite a few conventions and said that many rights were, that were recognized in these conventions have been violated. I still feel that our part 3 is quite broad to, to capture some of those rights, but it may not be in as specific a detail. So it's useful to cite those conventions and to sort of delineate some of the rights. And our courts have done it before. They've seen the international conventions, and have read some of those rights into the part 3, because then it makes it enforceable, right? That's the advantage of reading it into part 3. So I think it's certainly useful to cite those conventions, and our approach to international law is also very clear that if we are a signatory, then we can enjoy those rights.
Rashmi Vishwanathan, who teaches at law school at NLS, has a very good article again in the Wire on this. So perhaps you could also post the link in the chat box. I also just wanted to add one thing. Harish was talking about the number of cases that invite contempt in one form or another because the court's orders are not followed. But I felt that in this case, there was a difference in that the court's orders are being followed. That is not the problem, but the court's orders are being appropriated and imposed on situations which are very different, which shouldn't be, which were not intended to be a part of the court's orders. So you're imposing it on teachers, you're imposing it on schools which never had an issue with the hijab, and they are interpreting it to mean that the court has ordered every school across Karnataka to ban the hijab. So it's broadening of the court's order, not following of it, but manipulating it in one way. And here,
I agree.
What was a little disappointing was that a simple oral clarification could have taken care of that. But for some reason, in its wisdom, the court didn't feel the need to do that, even though it was brought to the court's notice several times on at least 2 or 3 days. But the court decided to not interfere. And that is what is disappointing. And that is what is a little bit different from the usually what happens in courts.
No, in fact, it is the contrary, right? You have vigilantism enforcing courts, the so-called a particular interpretation of the court's order, whereas the court's order, in fact, I think is quite narrow in what it said. I mean, it does say that you should not be exhibiting any religious symbols, etc. But the context of the court's order was also that only to ensure that there is no law and order problem. But it's the contrary what has happened, and it is vigilantism of a different kind, which doesn't have a place in this context. So Shah Rukh is right. I think it is not the same as a regular court order not being followed. Here it's being misinterpreted and twisted. Yeah.
They were saying that you don't wear it to the classroom, but to have people disrobe on the street outside, that is sheer twisting of the court's order, like Harish said.
And teachers are resigning from their posts. This is, I think, disappointing is a very, very mild word to be used in this context.
Okay, I think we've reached the end of our questions as well. So unless anybody else would like to add any comments, nobody's messaged us yet that they would like to speak. So I think we can close the discussion unless the two of you have any further comments you'd like to add.
Nothing, except it was a real pleasure.
Thank you.
Same here, pleasure, and thanks for asking me.
Thank you. This has been an extremely important discussion and definitely one that we must continue having. So we are extremely grateful to our speakers, Advocate Shah Rukh and Advocate Harish, for having joined us today, and to all our participants who joined us on a Sunday evening to have this discussion with us and engage with us on these issues. I know a lot of us here have been engaging in discussions daily regarding the ongoing hearing and have perhaps, including our colleagues from ILAJ, been unable to articulate answers to the questions that have been raised. So it's very important that as lawyers as well, we've understood the framing of these issues, especially on the questions of freedom, autonomy, and education. So thank you to both the speakers for shedding light on these issues and providing us a sense of clarity on the sort of questions that we should be asking as well. So with this, I will close our webinar. Thank you both so much, and thank you to all our participants.
Thank you. Thanks, Harish.
Thank you. Thank you. Thanks, Sharon.